Baker Botts, LLP, provides podcasts for educational purposes only. They are not legal advice and are not intended to establish an attorney-client relationship. This communication may constitute attorney advertising.
Hello, everyone. My name is Michael Loesch, and I'm excited to be here with you today for another episode of the Energy Enforcement Insider, the podcast that provides quick hits on the latest trends and developments in regulatory compliance and enforcement matters impacting the energy industry. Along with me today, as always, is Brendan Quigley from New York. Hello, Brendan.
Hey, Michael. How are you?
Good. It's great to be back with you again. We've got an exciting show today and a great guest. Do you want to kick us off?
Sure. Thanks, Michael. We're happy to be joined today by Joyce Adetutu, who's a member of Baker Botts' Global Projects Department, and she focuses her practice on assisting clients in understanding complex legal regimes governing the international trade of goods and services and cross-border investments. She has experience at matters involving economic and trade sanctions administered by the Treasury Department's Office of Foreign Assets Control, or OFAC, which is one thing we'll talk about today, and reviews conducted by the Committee on Foreign Investment in the U.S., or CFIUS, as it's known. Joyce has also advised clients with regard to the applicability of U.S. export controls to their goods, software, and technology. We're very happy to have Joyce here today to give us an overview of current issues and sanctions and export controls, and this has become a very important area of compliance focus for companies over the last several years. And I think coming at it from my perspective of DOJ, former DOJ prosecutor, is certainly something that has gotten the attention of the government over the last number of years, and potential penalties have ramped up, as has activity on both the civil and DOJ side. So Joyce, thanks for joining us today. It's good to have you.
I'm excited to be here. Thank you.
So I think coming at this from my perspective as someone who focuses on DOJ investigations, I will say DOJ has definitely placed increased emphasis on sanctions and export control issues the last several years. It's been almost 2 years ago since the Deputy Attorney General, Lisa Monaco, who's the number 2 official in the Department of Justice, described sanctions as the new FCPA. And DOJ has followed that up with an emphasis in increasing resources to the prosecutors who investigate these types of cases. They've added 25 new prosecutors to the National Security Division. So that's the division that really focuses on sanctions and export controls, whereas we often deal with the criminal division in the context of the FCPA and securities fraud, commodities fraud. The National Security Division has also added a new chief counsel for corporate enforcement, and that's all as part of a shift from what we've seen historically. The National Security Division, which I think was established in about 2006, has focused more on terrorism investigations. And the last 3 or 4 years, we've seen a shift to more corporately related sanctions and export control investigations. And we've seen a couple of corporate resolutions already in the sanctions and export control space. And one thing we've seen is traditionally over the last 30, 40 years, we've seen a lot of investigations in the securities fraud enforcement world where the DOJ and the SEC have teamed up to look at the same facts, and companies have reached joint resolutions with both agencies. And that's true in kind of the insider trading space or the kind of traditional securities fraud space. And it's also been the case in the FCPA space. So I think we're starting to see more of that, where DOJ is teaming up with OFAC on the sanctions side and potentially BIS or other agencies on the export control side. It's great to have Joyce on to talk about some of what she's seen in her practice in the world of sanctions and export control. Joyce, we covered your background a little bit in the intro, but what else should people know about your experience and expertise?
Thank you again for the introduction. I'm super excited to be here. I think one thing that I would highlight about my particular expertise is I used to be an upstream oil and gas lawyer and a large-scale energy projects lawyer. So one thing that I focus on in the international trade space is international trade compliance on cross-border transactions in particular. A lot of international trade practitioners have been in trade their entire practice. And so understanding a transaction from the diligence phase all the way to close is something that is unique in the international trade space and something that I'm quite passionate about. And it's become one of those practices that needs to be much more proactive instead of reactive, given the changing international trade landscape. So I spend a lot of my time focused on international trade compliance and transactions. And then outside of that, my expertise really lies in the energy and tech sectors, and with particular emphasis on sanctions and export controls as they apply to Venezuela, China, and Russia, although I've touched all of the world at this point. So that's a bit about my background, at least at a deeper level.
Great. And you mentioned sanctions and export controls. What are sanctions and what are export controls and how are they different?
Yeah, so sanctions restrict sort of the economic activity of US persons with non US persons or other countries for foreign policy or national security reasons. So, in more simple terms, sanctions can prohibit a number of activities, like, for example, blocking sanctions prohibit US persons from engaging in virtually all transactions with a blocked person, whereas there can be more limited sanctions on dealings in certain debt and equity of a sanctioned person. Export controls are going to be much more limited. They regulate the export of goods, software, and technology that are subject to US jurisdiction. And those export restrictions are going to apply not just to items that are in the US or that were made in the US, but even to some foreign made items with US origin content or certain items that have passed through the US. Export controls are really focused on sending those products outside of the US or taking them out of US jurisdiction and sending them to a third country.
And which US agencies are primarily responsible for regulating and enforcing sanctions?
So, for sanctions, they're primarily administered by the US Department of the Treasury's Office of Foreign Assets Control, or OFAC, which you mentioned earlier. But the US Department of State also has an Office of Economic Sanctions Policy and Implementation, and they implement certain foreign policy related sanctions. So, their sanctions are typically more limited. One of the examples I like to throw out is just like imposing visa restrictions. You'll see them often issue those sanctions at the same time the Office of Foreign Assets Control is issuing theirs as well on an individual.
And which US agencies are mainly responsible for the export control regime?
On the dual use side, you're looking at the US Department of Commerce's Bureau of Industry and Security. So that's going to be commercial and dual use items that aren't solely for defense purposes. And then on the other side, you've got the Directorate of Defense Trade Controls, which is responsible for administering the ITAR, or the International Traffic in Arms Regulations. And those regulate the export of defense articles outside of the US.
And how does a person or entity become subject to sanctions? What does that process look like? Is there an administrative finding, or how does one become subject to sanctions?
Yeah, there's a few ways that someone can become the subject of sanctions. For example, if a country is considered comprehensively sanctioned, sometimes under those sanctions regimes, the nationals of those countries, if they're in that country, would be considered blocked persons. Oftentimes, persons that will end up subject to sanctions are people that are closely tied to sanctioned governments, human rights violators, or any individual or entity that poses a national security or foreign policy risk to the United States. To answer your question, it's not really an administrative finding. What will happen is the US government will make its decision on who it wants to list as a sanctioned person, and then the Treasury Department will announce those sanctions. Honestly, we're signed up for Treasury Department alerts, and we get a new one every day about additions to the sanctions list. It really just depends on what's going on in the foreign policy landscape in the United States and how the US government wants to use sanctions to influence behavior worldwide.
Yeah, I think that's one of the tricky things I've seen about compliance and enforcement in this space is what was an FCPA violation 6 months ago is probably going to be an FCPA violation 6 months from now. On the other hand, with sanctions, you can have somebody who's a potential counterparty or somebody who you're doing business with or thinking about doing business with who may be perfectly legal to do business with them today, but tomorrow, if Treasury comes out with a designation, it can be certainly an OFAC violation. And under certain circumstances, it can be a federal crime to do work with them. So I think that's one of the trickier pieces in this space. What types of things can companies do to stay on top of this issue and make sure that they're not doing business with folks who are sanctioned or become sanctioned on a Tuesday afternoon?
Right. Yeah. Like you said, it's a constantly changing environment and things move really quickly. They can change overnight. So, one of the things that we really highly recommend is that companies impose a robust sanctions compliance program. It's a really great way to mitigate the risks of doing business around the world and engaging in cross border transactions. OFAC itself encourages entities to adopt a risk-based compliance program. Actually, so does BIS. And it really encourages entities to evaluate the areas where they are doing business and really approach their compliance based on the risk profile of the places they're doing business and the people they're doing business with. And so those programs would incorporate screening of employees, customers, agents, and other third parties, an auditing function to allow their sanctions compliance team to see what's working and what's not working and change as the legal landscape changes. They really encourage a reporting mechanism to allow people to report up if they see anything that's going on internally, and then getting involved in training and giving training to even the people that are on the ground and that need to understand the dynamics of sanctions and export controls so they know what to look out for and who to go to if they have questions. We also generally recommend looking at your agreements and determining whether it's a good idea to have your counterparties represent that they're not the subject of sanctions and that they're in compliance with sanctions and export controls, and sometimes even go so far as to have them represent that they have those compliance policies in place so that you can really mitigate the risks as you're doing business in other countries.
Great. And you mentioned a reporting mechanism, essentially a hotline or an email address where people within the company can make reports, correct?
Exactly, yes. And we've helped different size entities design these compliance policies because they really are bespoke policies. So if there's a reporting mechanism that works for one entity, it may not work for another because they're much larger. And so we've helped design and create these functions within entities to help them mitigate their risks.
Yeah, I think that's a great point. Across the alphabet soup of entities that we deal with in the enforcement space, whether it be DOJ or risk-based piece and the bespoke piece is something that I think all these regulators are expecting to see for a compliance program, not just the classic out of the box. This is our compliance program. And with that in mind, are there countries or regions that are generally considered higher risk? And has that changed over the last few years?
Yes, extensively sanctioned jurisdictions, which are basically considered the no list for US persons for virtually all transactions. So that list is Iran, Cuba, Syria, North Korea, and the Crimea and Donetsk People's Republic and Luhansk People's Republic regions of Ukraine. But then you're also looking at now that things have changed with Russia. Russia is going to be obviously on the list of higher risk jurisdictions. There are a number of sanctions and export controls imposed on Russia. And while it's not comprehensively sanctioned, it is just very difficult to do business in Russia with the current sanctions and export control regime that's in place. And then we're starting to see an increased sanctions and export control effort that targets China. The foreign policy landscape between the US and China is continuing to shift. And so we're seeing an uptick in sanctions and export controls that are imposed on Chinese companies and on products that are from China or going to China as well.
Got it. And what mental state is required for sanctions or export controls? In other words, do I need to know that I'm dealing with someone who's sanctioned? Do I need to intentionally deal with someone who's sanctioned? How does that work?
No, that's a great question. So, sanctions and export control violations are strict liability. So, knowledge is not necessary to be in violation of sanctions and export controls. There are mitigating factors that agencies might apply in the case of an enforcement action. They may look to whether you knew or had reason to know that you were engaged in an activity involving a sanctioned person. And then they'll look at things like, did you have a compliance policy and what controls did you have in place to avoid the violation, and whether you voluntarily reported the violation to the agency. But as far as the law is concerned, it's a strict liability situation.
Those mitigating factors are the agency essentially saying, because these factors are here, we'll decline in our prosecutorial discretion to bring an enforcement action, even though we could, correct?
Right. Or they might decrease the penalty or the requirements that they're going to place on the entity going forward, as far as reporting back to the agency or being on some sort of 2-year watch list or something like that. It might decrease the severity of the penalty.
Both OFAC and DOJ, for different reasons, have encouraged self-reporting. And I think if we're dealing with DOJ only, that can be very complicated, because you're wondering, was there in fact a criminal violation committed, which often turns on intent and knowledge of the individuals involved. However, if it's a sanctions related issue, those factors aren't there, right? So you may have a sanctions violation even without somebody knowingly or intentionally doing anything, which one could argue that you might as well also report. But there's a chance that the conduct may also get their interest as well.
I'll jump in there just because I think it's a fascinating topic, because it's not only just OFAC and DOJ, but there are often investigations that may involve SEC, DOJ, and OFAC, or all four, including the CFTC, SEC, OFAC, and DOJ. I mean, that in some of the digital asset cases involving the big crypto exchanges, where there are multiple agencies that have an impact. And anytime there's more than one agency involved, the decisions on how to proceed effectively and manage across those multiple investigations get very complicated. And if you are involved in an investigation that may have multi-agency exposure, it's critical to be thinking about those early. As soon as an issue arises, to be thinking about, okay, this seems like this is a CFTC issue. Is there also a sanctions component? Is there also a criminal component? And to really be looking ahead and trying to manage the matter with a view toward potential exposure across other regulators, even internationally as well. Joyce, what about the application of sanctions to non-US persons or to entities that are maybe affiliates of US entities or controlled by US entities, but are established and located in other jurisdictions? Sometimes they seem like they're out of reach, but is that true?
Yeah, that's what is referred to in our industry as secondary sanctions. And it's a good question. Secondary sanctions are really the extraterritorial reach of sanctions for activity that doesn't touch the United States. In the context of US sanctions, when you're looking at like primary sanctions jurisdiction, US persons are generally prohibited from engaging in certain activities with sanctioned persons. And if you're engaging in those activities, then you can be subject to a enforcement action. The same is true for non-US persons that are engaged in activities that have a nexus to the United States, whether a direct or indirect nexus. And so that's that jurisdictional draw, right? Even transactions that just involve the US dollar can trip that sanctions jurisdiction, that enforcement jurisdiction in the United States. When we talk about secondary sanctions, it's where that transaction has non-US persons and absolutely no nexus to the United States, not even an indirect nexus. For example, if a non-US person is engaging with the government of a comprehensively sanctioned jurisdiction, if that activity doesn't have any connection to the United States, the US could still impose what we call secondary sanctions on the non-US person for posing a national security risk to the United States. And there's a lot of instances where there's pushback on the US for doing this, for taking that extraterritorial reach. And the jurisdictional tie for it is saying we have the ability to impose these sanctions where there's a national security or foreign policy risk to the United States. And that's the step the US government tends to take when they have that.
Also, if you're a non-US person who causes a U.S. person to violate the sanctions, that could create exposure as well.
Correct.
Yeah.
Where a U.S. person might be acting on behalf of a sanctioned person. In some cases, we've seen like the hiding of vessel information on a purchase order or something like that. Causing a U.S. person to violate sanctions can trip that jurisdictional tie as well, both for secondary sanctions, but also primary sanctions, because at that point you have added that U.S. nexus.
Yeah. I will note that if folks are interested to learn more about some of these issues, Treasury, Commerce, and Justice issued a note in March of this year regarding some of these issues on the obligations of foreign-based persons to comply with sanctions. And you can look at that, which provides some further information on expectations from the government in this area.
Yeah, that's a great point. We've seen a lot more cross-agency collaboration when it comes to sanctions and export controls and with DOJ as well, so that people are really understanding that the agencies are working together in the implementation and enforcement of these.
On a related but not directly connected note, these international trade FCPA issues are a focus of a broad range of regulators, and I'm sure those in the energy industry are familiar with the CFTC's movement into FCPA, anti-corruption investigations involving the commodity markets, and there have been a few cases related to that they've started to come out with. There was an advisory back in 2019 related to that out of the CFTC Enforcement Division, and then there was a recent case at the end of last year involving an international fraudulent scheme and misappropriation of material non-public information that was part of that CFTC corruption task force. These are issues that are certainly getting the attention of all the key regulators.
Joyce, anything else we should know before we wrap up here?
We've covered quite a bit of ground. I would just say, in terms of sanctions and export compliance, it can be a difficult path to figure out, one, what your compliance policy should be and to establish those controls, and then to continue to monitor them on an ongoing basis. And that's exactly what we're here for. To the extent that folks are listening and find themselves in need of help, we're always here to help.
Great. Thank you, as always. Until next month, Brendan Quigley for Michael Osh and for Joyce Adetutu, and thank you for joining us, and hope to see you soon. Take care.
Thank you for listening to this Baker Botts podcast. Baker Botts has the experience, knowledge, and people to address our clients' most significant legal issues. For more information on Baker Botts practices, please visit us at bakerbotts.com. This presentation is provided by Baker Botts, LLP, for educational and informational purposes only. It is not legal advice and is not intended to establish an attorney-client relationship. Under the rules of certain jurisdictions, this communication may constitute attorney advertising.